at 31:02 in the afternoon in a federal courtroom that had seen 1,000 routine status conferences. Something happened that I have not seen happen this fast in 3 decades inside this system. 9 minutes. That's how long it took for a defendant who walked in wearing a tailored Navy suit out on bond, hugging his lawyer, smiling at his family in the gallery, to become a man in handcuffs being led through the side door by deputy U.S. Marshals. And no, this wasn't a surprise. Gotcha moment for television. This was the federal system doing what it is designed to do when the evidence shows a defendant has decided the rules don't apply to him. I've been around federal litigation for over 30 years. I've watched white-collar defendants talk themselves into 10-year sentences with one email. I've watched judges give second chances that most people never get. And I've watched, more times than I can count, how quickly a case turns when a defendant crosses one bright line: obstruction. Let me walk you through exactly what happened, because the details matter, evidence, not speculation. The defendant in this case, let's call him Ryan, was a 41-year-old founder of a fast-growing software company. The kind of person who speaks in calm, rehearsed sentences. The kind of person who tells cameras he believes in transparency. The kind of person who hires public relations teams before he hires trial counsel. He was under federal indictment for 27 counts, wire fraud under 18 U.S.C. CF 1443, securities-related fraud theories tied to interstate communications, conspiracy under 18 U.S.C. CF 3071, and money laundering counts under 18 U.S.C. CF 100 CF. The allegation was simple and catastrophic. Prosecutors said he raised money on a story he knew was false, revenue numbers inflated, customer contracts exaggerated, and a major partnership that existed only in slide decks and investor calls. The number that kept appearing in the filings wasn't small: 48 million. That was the amount investors allegedly wired based on representations the government says were knowingly false. And in the federal system, when you're talking about that kind of number, you're talking about guideline calculations that can swallow decades. So Ryan was arrested, presented, and released on a set of strict conditions, and the judge did what judges often do in these cases. She trusted supervision, she trusted the structure, she trusted that a defendant with a home, a business, and high-profile counsel would have every incentive to stay compliant. His release order wasn't vague. It was precise. Surrender passport, no new travel documents, no contact with witnesses, no encrypted communications to conceal evidence, no financial transfers above specified thresholds without pre-approval. And this is the part that becomes important: no interference with the discovery process. That's standard. That's not punishment. That's the price of getting to sleep in your own bed while your case moves forward. For 8 weeks, nothing happened publicly. Then, at 64:01 one morning, 64:01, not sometime early, not around dawn, federal agents executed a search warrant at a storage unit 15 minutes outside the city. They weren't searching for more fraud. They were searching for devices and records, because the government had filed an emergency motion the night before, and the title of that motion told you everything you needed to know. Motion to revoke release under 18 U.S.C. T. Joe, though. It's what prosecutors use when they can show, by clear and convincing evidence, that the defendant violated conditions of release, and that no condition or combination of conditions will assure the safety of the community or the integrity of the proceedings. Integrity, not headlines, not politics, not vibes, proceedings. When the hearing started at 3:03 p.m., Ryan looked like a man who had convinced himself this was just another legal skirmish. He sat upright, hands folded, whispering to counsel. He glanced at the gallery like someone checking whether his image was intact. Then the prosecutor stood up and said 5 words that changed the oxygen in the room. "Your Honor, we have proof." And I want you to understand how rare it is to hear that in that tone. Prosecutors can argue. Prosecutors can infer. Prosecutors can suggest. But "we have proof" means they walked in with something concrete, something the defense cannot explain away with a speech. First, the government introduced a set of communications recovered from a secondary device that was not disclosed to pretrial services. A phone Ryan did not report. A phone that, according to the affidavit, had been activated after his release. Not before, after. And the messages weren't vague. They weren't ambiguous. They weren't interpretation. They were instructions. One message to a former finance employee said essentially, "Don't talk. Tell them you don't remember. We'll handle you." Another message, sent through an encrypted platform, told a different employee to clean up shared cloud folders and remove anything old. That's not strategy. That's not defense preparation. That's obstruction. Then the prosecutor moved to the second piece of evidence, a series of attempted bank transfers and crypto transfers made in the days after discovery was produced. Not massive enough to scream flight on their own, but consistent enough to establish a pattern. $9,500 here, $12,000 there, a transfer labeled consulting, another labeled equipment. Then, a crypto wallet transaction that, when traced, led to an exchange account opened under a different name. And the prosecutor didn't say, "We think it's his." She said, "We matched the IP access logs to his home network." Again, proof. Third, and this is where Ryan's face changed, the government played a short audio clip from a recorded call. It was obtained legally, and the prosecutor made sure the judge understood that. In the clip, Ryan's voice is calm, almost bored. He says something like, "They're going to ask about the partnership. Don't say it wasn't real. Say it was in progress." Everyone says that. That's the moment the courtroom stops feeling like law school and starts feeling like real life. Because you can hear it. You can hear intent. And intent is what turns a messy business case into a federal criminal case with enhancements. Then came the fourth piece, a travel reservation. Not a ticket purchase, not a boarding pass, a reservation, a hold, a flight itinerary booked through a private charter broker created 2 days after the government disclosed it had video footage from his office building. The destination wasn't a conference. It was a country with no extradition treaty, and when the judge heard that, she didn't look at the prosecutor. She looked directly at defense counsel. The question was simple. "Counsel, why was this booked?" And here's the part people miss when they watch these moments on clips. The judge wasn't asking for poetry. She wasn't asking for righteous outrage. She was asking for an explanation that survives a sworn record. The defense attorney stood up and tried the familiar moves. He said the device could have been used by someone else. He said the messages were out of context. He said the transfers were ordinary financial management. He said the travel reservation was a business option that was never acted upon. And then the judge did what seasoned judges do. She narrowed the question until it couldn't be escaped. "Was your client in possession of an undisclosed phone, yes or no?" The attorney hesitated. Not long, maybe 2 seconds. But in federal court, 2 seconds can feel like an admission. Because it's not a hard question if the answer is no. You say no immediately, and you say it like you mean it. He didn't. He glanced at Ryan. Ryan did not nod. He did not shake his head. He stared straight forward, jaw clenched, blinking too slowly. And that's when I saw it, the first visible crack. His hand stopped moving. His shoulders stiffened. He swallowed like he was trying to push down something heavy. The judge asked again, slower. "Was there an undisclosed device?" The attorney finally said, "Your Honor, we're still investigating." That sentence is a death sentence in a bond revocation hearing, because still investigating means we can't deny it. The prosecutor followed up with one more fact, delivered without drama. The device was recovered from his locked desk at his office. The key was on his key ring at the time of arrest. At 3:12 p.m., the judge leaned forward, looked down at her notes, and then looked up. She didn't yell. She didn't lecture. She didn't perform. She said, "The court finds clear and convincing evidence that the defendant violated conditions of release, including prohibitions on witness contact and obstruction." Pause. Then, the court further finds that no condition or combination of conditions will assure compliance. Another pause. Then the line that changed everything. "Bail is revoked. Take him into custody." There are words you can say in federal court that are like doors closing. That is one of them. Ryan turned his head slightly, like he didn't understand the language he was hearing. His mouth opened, closed, opened again. His attorney reached toward him. "Too late!" A marshal stepped in, calm and practiced, and placed a hand on his arm. Ryan didn't fight. He didn't shout. He did something that tells you more than any statement ever could. He froze. His knees didn't buckle. He didn't collapse for the cameras. He just stopped, like his brain had hit a wall and couldn't go around it. Then the handcuffs came out. And if you've never been in a courtroom when that happens, let me tell you, the sound is not dramatic like movies. It's clinical. A small metallic click. But in that quiet, it might as well be thunder. Now, here's the legal reality that people need to understand. Bail revocation isn't a punishment for being accused. It's a consequence for breaking the rules you agreed to when a judge trusted you. Under 18 U.S.C. F3148, the government doesn't have to prove the entire case. They have to prove the release violation and show that the defendant's conduct demonstrates he can't be trusted on conditions. And obstruction, witness contact, evidence destruction, secret devices goes straight to the heart of the proceeding. It's not about flight alone. It's about whether the truth-finding process can function. That's why judges move fast when they see it. Because if the defendant is willing to manipulate witnesses while he's free, what do you think he's willing to do with 6 more months on release? And here's another point, one I've learned over decades. In white-collar cases, juries can forgive arrogance. They can forgive slickness. They can even forgive bad business judgment. But they do not forgive obstruction. Obstruction is consciousness of guilt made visible. It's not, "I made a mistake." It's, "I know what I did, and I'm trying to stop you from proving it." So what happens next? Ryan goes to a federal detention facility. He loses his ability to manage his defense the way affluent defendants like to. Private meetings at a comfortable office, calls at will, controlled narratives. From custody, everything becomes harder. Calls are recorded, visits are structured, documents move slower, the psychological advantage shifts, and strategically, the government just gained leverage. Because the person sitting in a cell starts doing math, and time math makes plea offers look different. Now let me ask you something, because this is where public opinion and legal reality collide. Do you think immediate remand like this is the right call when the evidence shows obstruction? Or do you think judges should try more conditions first? Home confinement, GPS monitoring, third-party custodians? Drop your thoughts in the comments. If you want legal analysis based on filing standards and how federal court actually works, subscribe, like, and share. And tell me, have you ever watched someone's confidence evaporate in real time when the system finally says, "No, not this time"?